Today, we have Pearl Eliadis, who taught our core course in law and rights and ethics, and also did a case study. And she's talking to us today about public liberties, pandemics, and pathogens. She clearly likes alliteration, which is great. So public liberties, pandemics, and pathogens. Without further ado, let me turn it over to Pearl, and I'm going to turn my video off. So Pearl,
thanks
please
very
take it away.
much, Chris, and thanks to Nicholas for organizing this, and a big shout out and hello to everybody, especially the Max Bell cohort. And as Nicholas said, we're going to be taking questions at the end, and I'm looking forward to hearing from all of you. So the title of this lecture is, or webinar is Public Liberties, Pandemics, and Pathogens. I am going to be running through several ideas and concepts as we move through this. Looking at policy challenges and legal limits, what the rules are that apply during emergencies, a couple of words about the media's role, particularly now, the role of the Canadian Charter of Rights and Freedoms during a pandemic, during a public emergency, and a little bit of a critical discussion about the so-called Securitisation Agenda. And then thought we should end on an optimistic note. What are the rules that apply when it's all over? Being number 9, I think Chris said, in this series, I've had the benefit of hearing several of the lecturers and thinkers who have been contributing to the series, and I'll try to tie some ends together and make connections as we move through the piece. So, what are we talking about when we're talking about public liberties or civil and political rights? I'm using those terms generically. We're talking about life, liberty, and security of the person. We're talking about legal rights, which include the rights not to be arbitrarily arrested or detained, for example, rights to counsel, and so on. The right to free speech, which includes the right to freedom of the press, and I put that in parentheses because that's a little different than the American model, which has a freestanding constitutional right with regard to freedom of the press in Canada. It's part of, and in a sense, subordinated to the right to freedom of expression, the rights to freedom of association and peaceful assembly, which I think all of you are feeling acutely in terms of the diminishment, if you will, of those rights, privacy rights, mobility rights, obviously a huge issue right now, and equality rights, which I'm including in this broader category. So I also want to talk about why it is I am focusing on equality. A lot of people will say, well, you know, why are we talking about equality when we're talking about public liberties? One of the things we see during emergencies, one of the things that we see during times of public crisis, is that it's often vulnerable groups that are politically unpopular at a given point in time, that often experience the brunt of measures that are taken to alleviate public emergencies. And that is one of the reasons why equality and non-discrimination rights figure prominently in the discussion today. So I remember Chris in his opening lecture talked a little bit about the fact that during times of economic shock or recession that there are specific things that you do, but in this case, many of our reactions might be very different in terms of the economic prescriptions. That's both true and untrue in the civil liberties context. Civil liberties were very much, as we understand them and apply them today, are very much the products of the post-World War II agenda, meaning that they came out of a massive global conflict where we realized the importance of not only new multilateral institutions, but also the importance of ensuring that we have norms, internationally protected norms that reflect international law, and that those laws now form part of the firmament of rules under which we are all operating. It is also true, though, that during times of crisis, and particularly in this kind of a crisis, a health crisis, a lot of the ways in which civil liberties behave are turned on their head. In this case, we're particularly concerned about claims that are made against the state because of state excesses or state measures, behaviors that are taken during a time of crisis. So that remains the case. But one of the things we always say about individual civil liberties is that they're from, for example, social and economic rights, which are generally not held to be justiciable, that civil liberties are generally thought of as individual rights, that they're negative claims against the state for the state not to do things, and that they're sort of preeminent rights. Well, in the context of this crisis, all of those have been turned on their heads. Civil and political rights are no longer the preeminent rights because the right to health has become the preeminent right. They are really no longer about individual rights because really what we're trying to do now is to protect the collective. They are no longer about negative rights, and we've seen this particularly in the economic context, but in other contexts as well, because duties are being imposed on the state to enact or to put into place policies and programs, positive rights, positive obligations, positive duties placed on the state to make sure that rights are respected, protected, and fulfilled, including people's rights to a basic level of income. And of course, certain rights are no longer justiciable, or at least their justiciability has been muted in the current context, whereas other aspects relating to health rights, which are traditionally not justiciable, have suddenly become first and foremost in the government agenda. Now, there are particular policy challenges and legal limits that apply during this kind of a situation. Rapid decisions are essential. So courts in the future and even now are much more likely to be deferential to decisions by governments. I wrote legislatures in terms of the frameworks that are already in place, but in fact, of course, all the decisions or most of the decisions being taken now are being taken by governments through the executive branch and not through legislatures, many of which are, of course, not sitting. Part of the reason why the courts are likely to be deferential, of course, is because public health in these circumstances will be viewed as a substantial objective. But at the same time, legislative instruments put into place during a time of public emergency are not built to last. They are designed to sunset. They are designed to end after a designated period of time. And that is critical, and we're going to come to that towards the end of the discussion. It is very important during all of this, of course, to protect vulnerable people. And that is in part linked to the equality objective I mentioned earlier, but also because the generic measures that are put into place to protect public health at a broad level are often insufficiently granular or pointed to protect individual concerns. Those include, of course, seniors, prisoners, certain racialized communities that may be particularly vulnerable, communities that have high population densities, indigenous peoples, and so on. It is also very important from a policy perspective that people understand the rules and perceive them to be fair. The government may put into place certain rules and guidelines, or indeed directives and orders, but if people do not believe them to be the right ones, if they don't understand the rational connection between the objectives sought and the means put into place, we risk social disorder. And it's extremely important for both constitutional and practical reasons that restrictions not be arbitrary or disproportionate. All of this is connected to Section 1 of the Canadian Charter of Rights and Freedoms, which says that you can limit rights provided that certain conditions are met. It must be prescribed by law. That does not include administrative decision-making unless provided for by law or a regulation. Now, the way that I can bring this home is to talk about the way in which the government has put into place the social distancing rules. Within the Public Health Act, which has been used to declare a public health emergency in Quebec, the government has issued orders, ministerial orders and orders in council, saying that we must keep a social distance of 2 meters apart. That is a government or administrative order. However, it is grounded in legislation, and my view is that this would be considered to be prescribed by law, because the capacity of the government to issue these types of orders is provided for in the Public Health Act. The limits that are imposed must be reasonable, and that means that they need to be rational, they can't be arbitrary, and they must be proportionate to the objective sought. They have to be demonstrably justified in a free and democratic society, and there has to be minimal impairment of rights if indeed there is a rights infringement. So overreaching, using a hammer when something much lighter would be just as appropriate. Those types of things often depend on evidence about what's actually happening and whether the measure in question is appropriate. Very brief example, some of you may have heard about the prohibition at the Jewish General Hospital with respect to women who are in childbirth having their partners with them. The hospital, for a number of reasons, has decided to limit the attendance of partners to the birthing room. The government has stood by the decision of the hospital while allowing people to change hospitals if they want. The question about whether or not that order would be considered to be reasonable would in part depend on the medical and clinical evidence with regard to the risk and the weight given to the principle of precaution. So these are empirical and evidentiary issues that are used to determine whether or not the act in question is justified under Section 1 of the Charter. So government responses. The Los Angeles Times memorably talked about whether, or asked the question about whether or not we're experiencing a coronavirus coup. Chris is quite I do like alliteration. And we've seen this all over the world. We've seen authoritarian governments using the excuse of COVID-19 to exercise extraordinary military and enforcement powers to crack down on dissent, to militarily attack areas of particular countries that may be overcrowded, resulting in some cases in injury and death, and using the opportunity to clamp down on political opponents. This is a real concern. It's not one, thankfully, we've had to deal with in Canada, but it's certainly something that needs to be watched carefully internationally. In Canada, we've seen the federal government enact a number of orders, including orders in council, to restrict people coming into Canada, including Canadian citizens and permanent residents. We had the interim order to prevent certain persons from boarding flights in Canada due to COVID-19, which is enacted under the authority of the Aeronautics Act, raising real questions about mobility rights under Section 6 of the Canadian Charter of Rights and Freedoms, which include rules in the interim order preventing anyone from boarding a plane if the passenger is symptomatic. Raising a question, of course, if the passenger is a Canadian citizen, whether or not their rights have been infringed, and if a court would find that to be reasonable in the circumstances. Some of you may also be aware of the fact that certain areas of Quebec have been designated as restricted areas, and that the government is blocking access into and out of those restricted areas, mainly in an effort to make sure that low infection areas stay that way, particularly areas that have limited access to public health and healthcare. There are, I think, genuine concerns about whether or not it is legal when those restricted areas are on a border between Quebec and Ontario, in terms of whether or not Quebec residents, for example, can get out of the province in order to work and then come back in order to go home. Right now, I've been receiving calls at my office from people saying that they cannot get, for example, from Western Quebec into Ontario and home again, even though their place of business, which has been designated as essential, is in Ontario. And so there are real problems there in terms of interprovincial rights. As you may have heard, the federal government under the Quarantine Act has barred so-called irregular border crossings into Canada as a result of the current pandemic. The Canadian Council of Refugees has spoken out strongly against the measure and its impact on persons seeking asylum in Canada, particularly, of course, coming up from the United States, where it is no longer clear that that country, from a refugee protection perspective, is currently appropriately designated as a safe third country. The favorite one on everybody's list, of course, is gatherings and social distancing. These raise issues under Sections 7 and 9 of the Charter, Canadian Charter of Rights and Freedoms, the right to life, liberty, and security of the person, and Section 9, which deals with arbitrary arrest and detention. The government of Quebec has issued rules with regard to both of these issues, which are separate issues. In other words, you're not allowed to have a gathering and you're not allowed to have social distancing under 2 meters. So for individuals who go to have a picnic together, who keep the 2 meters apart, they are still in violation of these orders because it still constitutes a gathering. And a few people in the last several days have been fined as a result of not understanding that difference. I would point out that there are problems in the way that the Quebec government, in my view, has put into place these measures. The underlying legislation is the Public Health Act, and it prevents or it puts into place measures that require, allow the government to impose fines, in this case between $1,000 and $6,000, on anyone who violates an order. An order, of course, is not defined in the Public Health Act. You have to go to the emergency measures that have been put into place. The problem is that under the legislation as it's currently drafted, it requires that the person actually refuse to obey an order. And I've personally seen on my walks, where I maintain social distancing and do not have any participation in gatherings, people being stopped who clearly have not been warned. And I've spoken to one of the police inspectors at the SPVM, and there clearly is a difference of opinion about whether or not the provisions of the Act regarding warnings have in fact been met. I'm seeing people being fined on the spot without a warning. I think this raises real concerns in terms of the police acting more zealously, if you will, than they might otherwise do. And this raises an important point, which is that the Supreme Court of Canada has said over and over again that the police, when they're engaged in coercive acts, and particularly when rights are in question, must behave in a way that is authorized by law. The reflex position in a liberal and democratic society is that you're allowed to do everything you're allowed to do unless you're not allowed to do it. And from a policing perspective, it's extremely important that the police not only engage in behavior that is legally justified, but they themselves understand the nuances involved, which until relatively recently has not always been obvious. So all of this means that the rule of law still applies. The police still need a legal basis to act and to interfere with rights, even in an emergency situation. Governments can, as a matter of international law, derogate from or deviate from certain rights, provided the emergency is publicly declared. In Quebec, it was publicly declared on March 13th, which was 2 days after the World Health Organization declared the global pandemic. But there are certain rights, and hopefully this won't be surprising to you, that you cannot derogate from, even in a time of emergency. Or maybe particularly in a time of emergency. And those, of course, include the right to life, the right to freedom from torture, slavery, which I didn't write down, but is obviously one of them, and the right to non-discrimination. And this, I want to pause on this again because it is not unusual to see in situations of public emergency that the government uses its emergency powers in order to clamp down on groups that are considered to be politically unpopular. We saw this go on for years in Sri Lanka, particularly in the years leading up to and just after the war in 2007, 2008, and 2009. And this is not an unusual phenomenon. So again, whatever measures are put into place, they cannot be enacted or put into place on the basis of discriminatory measures, or indeed have a discriminatory impact that does not stand up to constitutional scrutiny. And the responses have to be based on measures that are necessary, proportionate, and based on precaution. These rules come from the ICCPR, the International Covenant on Civil and Political Rights, and that, of course, is the international legal instrument that Canada has ratified and that set out the ways in which governments can derogate from or deviate from international standards. So governments should heighten their vigilance, and I would argue that during a time of public emergency, it's particularly important that we be vigilant about not only protecting our public health, of course, but also to make sure that governments are not overreaching. And the reason for this is not that, particularly in the Canadian case, that governments are misbehaving. It's because we no longer have legislative oversight. The government has done a finesse, if you will, entirely legally around existing legislative structures, and we have reduced or in some cases eliminated judicial oversight of the way in which law enforcement and the government is behaving. And so it's particularly important in these circumstances to enhance our critical scrutiny of the rules that are being put in front of us, and civil liberties groups like the Canadian Civil Liberties Association, and in Quebec, the Association of Rights and Liberties are in fact engaging in critical and granular examination of the measures that are being put into place. It's really important, again, that we protect vulnerable people, and when legislative provisions come into force, there have to be sunset clauses in them. In other words, when emergency measures are enacted, built into them, you are supposed to have rules that say that this measure will only last for example, 10 days, which is the case in Quebec under the Public Health Act. So those rules are built into the orders that are being put into place practically on a daily basis. Governments need to avoid overreaching, infringing rights wherever possible. They need to avoid minimizing or eliminating judicial oversight. I'll have a couple of examples of that later. And wherever possible, of course, minimize the use of coercive force. Interestingly, although freedom of thought and conscience cannot be derogated from, even in times of emergency, freedom of speech actually can be under the International Covenant on Civil and Political Rights. And it is not surprising that you will see authoritarian governments who are engaging in so-called coronavirus coups taking advantage of this in order to put restrictions on the press. We've seen this in spades. In the measures put into place by the Duterte government in the Philippines, where there have been extensive restrictions placed on the media and on social media, including fines and prison time for individuals who circulate so-called fake news, which in some cases has been assimilated to criticism of the government. I mean, obviously, these are not the sorts of things that were anticipated by the International Covenant on Civil and Political Rights. They were designed to ensure that during times of war, that appropriate censorship can take place. Having said that, I think the language of war against the coronavirus, war against a public health threat is not helpful to the media, in part because it engages with that idea that it's okay to censor the media during times of crisis. And I think that needs to be scrutinized with great care as we move forward. David and Cindy's webinar a little while ago, a few days ago, talked about the role in the United States and the American media of journalists who are to some extent deciding whether or not they're, for example, going to broadcast parts of what the President of the United States says. This raises concerns about self-censorship, but I would suggest, at least in the Canadian context, that really it only highlights what the media does all the time. The media is in the business of curating on a news cycle what is or is not news. They do it all the time. That's their job. That's what we expect them to do, and that's the role that they play in society. For the decision decisions about what constitutes news to a large extent is left with the media, because freedom of the press allows the media to do precisely that. So in a sense, it's business as usual, but of course, because of the current circumstances and the role of certain authoritarian leaders, not only in the States, but also internationally, this issue has become much more prominent than I think it was before the crisis. In terms of what's happened to the Canadian Charter of Rights and Freedoms, why aren't we talking a lot about that? Well, I think we're not talking a lot about that right now because everybody is so concerned about public health and scrambling to make sure that people have food on the table and are able to educate their kids and do all the sorts of everyday things that are important. But we do need to remember that the Canadian Charter of Rights and Freedoms is still there. It has not gone away. Canada has not passed the Emergencies Act at a federal level. In Quebec, we have declared a public emergency under the Public Health Act, but that does not involve the invocation of the notwithstanding clause of the Canadian Charter and Freedoms, and moreover, it has not restricted the rights under the Quebec Charter of Human Rights and Freedoms. So all of those principles still apply. The only thing that has changed is what's going to be considered reasonable in a Section 1 type analysis. And so it's important for us to remember that none of our rights and freedoms have gone away. The context has changed. Legislative deference will probably change as a practical matter because of the way in which public health emergencies work, but all of those rights and privileges and our obligations as citizens are all still there. And that means that we need to care about reasonable limits, making sure the limits put into place are reasonable. That means we need to make sure that the measures put into place are prescribed by law wherever possible. If they're not, then they're not protected by the Charter in the same way. And that we look at what is being done in other free and democratic societies around the world. So I want to take a couple of minutes now to talk about the so-called Securitisation Agenda. And I need to declare my bias right up front here. I am deeply suspicious of the Securitisation Agenda. I don't think it means anything. I think it is attractive because it can mean lots of things to lots of people, and therefore allows us to project our own particular concerns and interests into a broad range of security concerns, but does not really permit critical analysis in the way that we would do under a human rights analysis. And so I think that it certainly has become very popular to talk about security and the securitization agenda, but I want to introduce a few challenges, critical challenges to the concept. So we know that security is being used to create new offenses and new directives and new behavioral norms. But sometimes the rules are not always clear, or how people are supposed to respect them is not clear, or they may actually decrease the security of particular individuals who are vulnerable or who are from marginalized communities. And it all depends on whose security you're actually talking about. So in Quebec, I've talked a little bit about the problems with gatherings and social distancing. On the one hand, those types of rules have ensured and appear to be there's starting to be some evidence that they're working to flatten the curve, to make sure that we're not spreading the virus. But on the other hand, for certain types of individuals, for example, seniors living in residences, not having family members who deliver essential services because the home is unable to do what they need to do, may actually be placing certain seniors, those who are in a particular physical or mental state that makes them need to have individuals coming from families to help them, places them in particular danger. Interprovincial mobility rules, I think, are currently violating Section 6 of the Canadian Charter of Rights and Freedoms. I had someone call me, as I mentioned earlier yesterday, who was trying to get out of Western Quebec into Eastern Ontario in order to do his job, and has been blocked at the Ottawa River, not able to go through, losing money on a daily basis. It is not clear. It is clear to me that the Quebec government can prevent people from coming in. I'm not sure that they can actually prevent people from going out to do their jobs. On last weekend, the Quebec government created new isolation orders that allow people to be placed in isolation for a period of 14 days as compared to the 72-hour rule that existed before. And this creates concerns for access to justice and habeas corpus. One of the fundamental writs that exists to protect personal security when people are detained, that is normally something that is exercised in the original jurisdiction of the Superior Court of Quebec. In the case of Quebec, now they're saying to people that they need to go to the Court of Quebec, which is the lower court. There's no procedural mechanism that's put into place to deal with that I'm aware of. Real problems for individuals who have been forcibly quarantined. And the government has recently allowed warrantless orders, which allow the police to obtain cell phone data and localization information, and of course, without warrants or without the requirement to have warrants, there are real concerns about the conditions for privacy. So the critique of the securitization agenda is what security are we talking about? Are we talking about human security, security of the person? Are we talking about national security, territorial security, food security, water security, energy, all of these? Whose security are we looking at? As I mentioned earlier, seniors are particularly disadvantaged in this climate. Workers who have to be there, unlike us, who can do much of what we do online. People who are homeless, prisoners. All of these people have had their security diminish or disappear as a result of the measures put into place to supposedly enhance their security. There's new data coming from the United States indicating that the rates of deaths of African Americans are disproportionately high. Again, possibly the result of the fact that the rules as they are applied are not responsive to the particular concerns of individuals, but are overly focused on large collectives, and as a result, individuals who are in these circumstances are negatively impacted. So the securitization agenda ignores the tension between individual security and collective security. People who are fans of the securitization agenda or security as a right often refer to it as a meta right. In other words, it's the right that you use to go and get other rights. It's a higher level concept that ensures the fundamental protection of a particular set of interests. But of course, if you look at security as a fundamental meta right distinct from the individual right to life, liberty, and security of the person, which is a specific human right that we know what it means, we know what its content is. I have no idea what security means at a much broader level. There's very little normative language around it, let alone internationally tested standards beyond the human rights context. And we risk, I think, as a result of using the securitization agenda, losing the lens of other fundamental meta rights, like human dignity, like equality, and even freedom of speech. So my suggestion when we're talking and when you hear language about the securitization agenda is to be skeptical, to ask yourself the question about whose interests are being protected, whose security matters here. Is the response of the government proportionate, rational, and is it based on evidence as a result of precaution principle? So I thought it was important for us to end on a cheerful note. So when we get back to normal, not if, but when, there are a few things that from a policy perspective, I think we need to keep in mind as we're thinking about life after COVID. The first one is, of course, that emergency powers should never be normalized. Sri Lanka, again, is a great example of that. When the Tamil independence movements started to flex military muscle, one of the things that happened was that the government put into place emergency measures that basically stayed there for decades. Now, I'm not saying that that will be the case here, but certainly we do have precedent in other countries, in other communities, of emergency measures, relatively strong and unusual powers being quote unquote normalized because they're kept into place for a long period of time after the crisis has passed. It's going to be important that judicial oversight, in this case, of course, it's going to be hindsight, will be restored at a practical level. Technically, it's still there, of course, but the judiciary is scrambling, as we all are, to try to get everyday jobs done. The question, for example, about whether or not for gatherings and for social distancing, whether or not there actually does need to be an actual refusal to obey the law before the police issue a ticket, I think will be the subject of, will be fodder for class actions if this is not cleaned up sooner rather than later. As a general matter, I think it's really going to be important for us to roll back any sort of pandemic policing issues where people are carted on the streets. Toronto and Halifax in particular, over the last year and a half, have worked really hard, the police and their communities, to make sure that carting, which is the practice of stopping people and asking them for their identification on the streets, is eliminated because of the discriminatory impact that these types of measures have demonstrably had. And so, question mark, are we moving back to that framework, and how are we going to move away from it after the crisis is over? And so, how do we learn from this crisis? I think this is really one of the most interesting policy questions from a sort of civil liberties perspective, because it really spills into not only sort of traditional policing, but it also looks at the close connections between civil rights on the one hand and social rights on the other. We have seen, particularly with regard to long-term care facilities and seniors residences, we've seen that this pandemic has exposed serious structural and systemic deficiencies in those systems, and we've seen that these deficiencies have been exacerbated by the current crisis. And we really, I think, have an opportunity and an obligation after this is over to look at the way these systems are run, and to make sure that we do not put ourselves back into a situation where our loved ones who are in these facilities end up being unable to access their family members, and at the same time exposed to personal care workers who are undertrained, seriously underpaid, and often inadequately employed in order to offer the required services to their residents. I've been getting calls all week from people who have family members in these facilities who are unable to reach them, and particularly if they're in end-of-life situations, the situation is, in my view, dire. And so I think we have a fantastic opportunity where this pandemic has really laid bare fundamental social problems that I think we all need to care about and focus on. I also want to say that, you know, the critical remarks, if you will, that I've made about pandemic policing and the role of the police in terms of the warnings and so on are not intended to be critical of the police. I think our police forces have a very tough job at the best of times. It's tougher now than it normally has been, but because of the speed at which we have been moving, I don't think, in fact, in some cases, I know the police have not been adequately informed of what the rules are and how they work. And I've gotten that firsthand from several officers. So making sure that police are properly briefed in person, as well as getting, you know, packages of emails sent to them that they don't have the time to look at carefully, I think is fundamentally important. And that speaks to transparency and having people be on side with these new rules. And of course, all of this requires, in terms of future lessons, and I'm going to be closing on this, more granular capacity for us to respond to the needs of vulnerable groups and communities. We've been seeing discussions about whether prisoners should be released, for example, those who are not in maximum or medium security, but who are on intermittent imprisonment, or those who pose minimum security risks. And of course, the large number of individuals who are in remand, people who are in remand, that is, they've been charged, they're incarcerated, but they've not yet been convicted, make up a significant proportion of our prison population. And we don't really have any method in place to help those people. So in closing, I think we really do have a fantastic opportunity to look at lots of things that I think were maybe, if not broken, certainly damaged and not in great shape before this happened. All of this, I think, has really brought to the surface a lot of those issues, and we have I think, an opportunity and an obligation to address them after it is all over.